Hello, and welcome to this session on lease expiry and fixtures, which I'll be presenting for Legal Futures. My name is Mark Shelton. I'm a non-practicing solicitor and commercial property management law trainer, formerly in practice with Linklaters, DLA Piper, and Evershed Sutherland. So, tenant mobility is increasing. So, the question of what works the tenant can carry out and what that means for the rights and remedies of the parties when the tenant leaves the premises becomes ever more important. And in this webinar, we're going to be looking at how alterations fall to be dealt with upon lease expiry. We'll be looking at compensation for improvements, reinstatement obligations, tenants' fixtures, and yield up provisions. So that's the agenda. These are the topics we're going to be covering, and we'll be starting. As the slide indicates, with compensation for improvements. Not a sort of very live topic, so we'll kind of deal with it and get it out of the way. But who's entitled to compensation? The right to compensation for improvements is set out in Section 1 of the Landlord and Tenant Act of 1927. You can't contract out. The person entitled to the compensation is the tenant in possession at the end of the term, whether or not they were the people who carried out the improvements, or it might have been a predecessor entitled. Doesn't matter. Tenant in possession at the end of the term is entitled to the compensation, but they must be in possession. So a tenant who has sublet the whole of the property is not entitled to claim compensation. And that entitlement doesn't pass to anybody else, like the subtenant, it just disappears. What about a tenant who has sublet part of the property? We don't know. There's almost no case law on Section 1, so that's a matter of speculation. Now, when does the entitlement arise? It is at the termination of the tenancy and on the tenant quitting the holding, as the Act says, so when they leave the premises. So